I'm very pleased to address, although remotely, this important side event organized by the Council of Europe and the government of Lithuania. It would be no exaggeration to say that the triple planetary crisis of climate change, pollution, and loss of biodiversity threatens our viable future and life on this planet. Humanity is facing a true existential emergency. Faced with such a situation, the question is no longer whether, but how various social actors, including as appropriate the judiciary, should act to address the adverse impacts of these events on the lives, health, and well-being of individuals and the quality of the environment in which we live. In 3 recent cases, the European Court of Human Rights was asked to determine whether and to what extent the European Convention on Human Rights protects the human rights of individuals from the adverse effects of anthropogenic climate change. The Court's answer was clear. It is a matter of fact, based on ample and sufficiently reliable scientific evidence, that anthropogenic climate change exists, that it poses a serious current and future threat to the enjoyment of human rights guaranteed under the Convention, that states are aware of it and capable of taking measures to effectively address it, that the relevant action to address it must be taken urgently, and that current global mitigation efforts are insufficient to meet 1.5 degrees centigrade limitation of global warming. On the basis of these findings, in the Verein Klimasenioren in Schweiz and others case, the Court determined the scope and nature of the state's margin of appreciation and positive obligations in this context. The Court differentiated between, on the one hand, the commitments to the necessity of combating climate change and its adverse effects, in respect of which the states have a reduced margin of appreciation, and, on the other hand, the choice of means designed to achieve those objectives, in respect of which the margin is wide. In order to assess whether a state has remained within its margin of appreciation, the Court set out a number of factors which the competent domestic authorities, be it at legislative, executive, or judicial level, must consider when devising and implementing the relevant regulatory framework to address the adverse effects of climate change. In reaching these findings, the Court was well aware of its responsibility as a human rights court and of the limitations of its judicial role. The Court recognized that the domestic policy maker must be given special weight, most notably because measures designed to combat climate change and its adverse effects primarily require legislative action, which necessarily depends on democratic decision-making. However, the remit of domestic courts and of the Court is complementary to those democratic processes. The task of the judiciary is to ensure the necessary oversight of compliance with legal requirements. The Court has thereby demonstrated that it is ready to shoulder its part of responsibility regarding climate change, in accordance with the principle of subsidiarity and within the remit of its role under the Convention. However, judicial involvement, be it at national or European or indeed global level, is clearly insufficient to tackle the effects of climate change. The responsibility is primarily for the domestic and international policymakers to ensure that climate change does not bring us to a point of no return. The courts must do their share and ensure oversight of compliance with legal requirements, including under the Convention and other instruments of international human rights law.